I'm Eric Lanigan with Lanigan&Lanigan attorneys in Winter Park. I want to talk for a minute about something that came up in a case of mine just in the last couple of weeks that reminded me of a principle that I need to make sure that I always apply and that I would certainly recommend to other lawyers. And that's the second opinion. And what happened is I received a frantic call from some people who had a case that involved some rental property renovations in Central Florida, and they got in a dispute with the contractor, and they ended up in a lawsuit where the contractor was suing them and also suing to foreclose on a construction lien. And it's quite a nightmare. And there was no written contract. It had been an oral contract, which is always a nightmare in and of itself. When you get into a he said, she said scenario, which is an oral contract, in my opinion, in the end, everybody loses. On top of that, they're facing a construction lien, which means that this contractor, if he prevails at all on the construction lien, he recovers all of his attorney's fees, which I've had cases where the attorney's fees in those kind of cases can be double what the actual monetary outcome of the case might be. So the case was a nightmare, and it was getting ready to go to trial in 10 days. They were frantically searching for a new attorney because their existing attorney was sick. I think maybe the case had caused this person to basically have a mental breakdown, I think. But in any way, they had to get a new attorney, and there were things that had not been done. The court had entered sanctions against the attorney, $2,500, $3,000. The homeowners were not going to be allowed to call any witnesses other than those listed by the plaintiff. They couldn't put into evidence any exhibits other than those that the plaintiff produced. So from a defendant standpoint, it's a nightmare case. So bad that even the judge scheduled a hearing when I filed an appearance to sort of make sure I understood what the whole picture was here, and literally said, well, Mr. Lanigan, having heard all of this, I'm going to give you a chance to back out if you want to do so. And we sort of took the attitude, well, what the heck, somebody's got to try this case, it might as well be me. So we start frantically preparing for this trial over 10 days, and it became very clear in the beginning that both sides had sort of coalesced around a couple of issues as being the deciding factors in the case. And not because we're rocket scientists, maybe just because we're coming in with a fresh set of eyes and an open mind about what's going on, we're going through all of this, and one day, a few days before the trial is going to start, I'm going down this several-page billing, the final billing from the contractor, with all of these various things in it. And as my eyes are scrolling down there, I hit a couple of lines that are all talking about electrical work, rewiring, putting in new electrical circuitry, which is, not just replacing a light switch. And I knew from a case years ago that, okay, this is going to require an electrical contracting license. And I also remembered something about the statute that if you're out there doing work that requires a particular license and you don't have it, then you got real problems. And this issue had never been brought up, and it had never been discussed in any over 3 years leading up to this trial. So sure enough, we went in. The contractor did not have an electrical contractor's license. So we knew all we've got to do is get this guy to admit on the stand that A, he did the work, and B, he didn't have an electrical contractor's license, and he didn't sub the work out to an electrical contractor, all of which I was very, very sure were true. So sure enough, we get on the stand, and we go through there, and buried in all the questions is that information. And I even took the definition of what constitutes electrical contracting work, worked it into a question, and said, these electrical things that you did here on the bill, would that come under that definition that I just referred to? And he says, well, yeah, it would. Well, what the statute says is that if you do that kind of work and you don't have the requisite license, you have no construction lien. So right there, his construction lien is out the window. Now, what about the rest of his contract? The statute also says that if you don't have the requisite licensing, then you cannot collect for any labor, material, or services. Any labor, material, and services provided under that contract. So our position at that point was the construction lien is out, which is a victory in and of itself, because that probably would have been, by the time all was said and done, I'll bet the attorney's fees from the other side, if they prevailed on a construction lien, would have been $75,000. So that goes out the window. And then there was the entire argument about the statute clearly says, Judge, you cannot collect for any materials, labor, services provided under the contract that encompasses, in which that work is encompassed. So this was an argument that had never been brought up, but because a fresh set of eyes looked at the case with sort of an open mind, it came up and became, I think, the determinative factor in the case, which reminded me that I can be just as much a victim of that as anybody else. I can be the one who says, I'm so fixated on what I think are these particular issues that I lose the sight of what else might be going on in the case. So I've taken the step. I've got a case that's going to be going to trial probably in about 6 weeks. I took the trial notebook. I went to a respected friend, colleague, and said, here's what the case is about. Here's what I see to be the fundamental issue. We'll pay you for a day to sit down, go through this, and see if something else jumps out at you. Or if you think that what I think is important really isn't important, and maybe something else is more important. Bring those fresh set of eyes in the case. If your lawyer is confident, he will appreciate that second set of eyes. Better to get that opinion in before you go to trial than have your client show up after trial and say, well, I was talking with so-and-so, the attorney down the street, and he said you could have done this, you should have done that. Because now it's too late to do them. You just look bad because you didn't. So if you're the client, ask your attorney, has he gotten a second set of eyes on this? If you're the attorney, don't hesitate to go out there and bring a friend in and say, look, take a day to go through this file and tell me if I'm missing something or if I'm focused in the wrong place. Again, I'm Eric Lanigan, Lanigan&Lanigan, attorneys, Winter Park, Florida.